One of the striking things to me about how the founders viewed government is that they thought everything government does always comes back to one basic thing that government is there for, namely to secure your rights on the basis of consent. If government's doing something that goes beyond that, goes beyond securing the rights of the citizens, it's violating the basic terms of the compact that citizens make with each other when they form a society. For us today, we look back on that and we think, oh, how cruel, how mean. We think you can't really have liberty if government isn't providing you with a whole host of benefits. Franklin Roosevelt made this theme famous in his 1944 Second Bill of Rights speech. The point of his speech was, we need a new Bill of Rights because the founders wasn't good enough. And he included in his new Bill of Rights the right to a comfortable home, the right to a highly paying job, he called it remunerative job, and above all, he even includes the right to recreation. Founders would have said, no, you don't have a right to recreation at someone else's expense. What you have is the right to go out and get a job and provide for yourself through your own labor or through voluntary dealings with others. How does government secure these rights? What exactly does it have to do? I sketched the answer to this question in my first Constitution 101 lecture. Now I want to explore a little more what is required in specifically three areas: religion, property, and morality. Since these three are all instances of domestic and not foreign policy, the answer to my question will be found mostly in state constitutions and laws of the founding, although we will see that the federal Constitution did have a limited role to play. I start with religion. Among the many things that the founders took pride in, perhaps the most important was their establishment of religious liberty. Prior to 1776, the prevailing view was that government should forbid or discourage any religious opinions or religiously motivated actions that were not in conformity with the religion approved by government. As recently as 1774, 2 years before independence, Baptists were still being jailed in Virginia for the crime of preaching without a government-issued license. Connecticut was fining people for the same crime. The founders' conception of religious liberty has two main elements. First, religious liberty, or free exercise of religion, or the rights of conscience, those all mean the same thing, meant not only that all persons may worship God in the way they think best, but also that all are permitted to follow what they believe to be God's laws in their daily life outside of church. If I believe God wants me to sacrifice animals or drink wine in the course of a religious ceremony, I am permitted to do that. If I believe God requires me to close my business or refuse to work on Saturday or Sunday, I am permitted to do that. But, and this is my second point, religious liberty has limits. In the First Amendment of the Constitution, the right is called simply free exercise of religion. But in many founding documents, religious liberty is hedged in with qualifications. Take the 1780 Massachusetts Bill of Rights. Quote, "No subject shall be hurt or restrained for worshiping God in the manner most agreeable to the dictates of his own conscience, provided he does not disturb the public peace." Unquote. This formulation is typical. Everyone has religious liberty, but no one may abuse that liberty by disturbing the public peace. When people today talk about, for example, Muslim advocacy of violence against infidels, they often forget about these limits to religious freedom. No one has a right to practice the religion of the Aztecs or the religion of Baal mentioned in the Old Testament, in both of which children were sacrificed to the gods. No one has the right to murder infidels or incite others to murder. In the founding, there are in principle no exceptions to laws made to protect person and property. I say in principle no exception. What I mean is that in the founding, exemptions were selectively, but hardly always granted, notably for the Quakers, who refused to serve as soldiers. President George Washington wrote a letter to the Quakers in which he indicated with perfect clarity what religious liberty means in their case. He begins with an affirmation of the religious liberty right. Quote, "The liberty enjoyed by the people of these states of worshiping Almighty God agreeably to their consciences is among the choicest of their rights. While men perform their social duties faithfully, they do all that society or the state can with propriety demand or expect. Except for the Quakers declining to share with others the burden of the common defense, there is no denomination among us who are more exemplary and useful citizens." End quote. Washington is being polite but firm here. Yes, he is saying, you Quakers have a right to religious liberty, but there is a condition. You must, quote, "perform your social duties faithfully," unquote. Mostly you do that, says Washington, except for one huge thing. You refuse to assist in the common defense. Washington implies that this refusal is not justified by the right to religious liberty. To understand why the founders did not think there was a religious right to exemptions from assisting in the common defense or from any other laws, we have to remind ourselves why laws are instituted at all. The answer given in the Declaration of Independence is, governments are instituted to secure these rights. The founders used the term social compact to describe what happens when people decide to create a civil society or to join one already in existence. The social compact is an agreement that all will obey the laws that are established to secure the equal natural rights of all. Quakers are as much members of the social compact as anyone else. They too must obey the laws that protect life, liberty, and property. One of those laws may require citizens to fight in time of war, when the rights of the people are threatened from abroad. The survival of the community, its right to life, may depend on that. The Quaker refusal to fight is therefore a violation of the terms of the social compact. They are liable to punishment for that refusal. But Washington does not leave it at that. He adds a final conciliatory paragraph to his letter. And notice that he now adopts a personal tone. He says, "my wish" and "my opinion," speaking of his own personal views, as opposed to the strict requirements of the social compact. Quote, "I assure you very explicitly that in my opinion, the conscientious scruples of all men should be treated with great delicacy and tenderness. And," continues Washington to the Quakers, "it is my wish and desire that the laws may always be as extensively accommodated to them as a due regard to the protection and essential interests of the nation may justify and permit." End quote. This final paragraph states Washington's personal wish and desire. He does this because although there can be no religious liberty right to disobey the laws that protect the citizen's natural rights, there might be good reason to make an exception in some cases. So if the Quakers are going to be exempt from the duties of national defense, it has to be as a favor to them. It is not a matter of natural right or constitutional right. Washington has a wish and desire that the laws be accommodated to the Quakers. But he adds, again reminding them that this is not their right, that the accommodation would only be made if the protection and essential interests of the nation permit it. When Washington says the laws would have to be accommodated to the Quakers, he means that this decision will be made not by himself as president, not by the judiciary, but by Congress, the lawmaking body. It is a remarkable thing that Washington's letter to the Hebrew congregation at Newport is more friendly to Jews than his letter to the Quakers is to Quakers, his fellow Christians. That is because, unlike the Quakers, the Jews had no problem, quote, performing their social duties faithfully, unquote. So far, I have talked about where government must refrain from acting, from interfering with religious liberty. But I have not mentioned the main way government protects that right. It is by means of national defense, the job of the federal government, and by means of the criminal law, the job of the state governments. Religious liberty is threatened not only by positive government actions, but more often by government failure to act, by prosecuting those who would harm people because of their religion. Consider recent events in the Middle East. Christianity has been almost totally exterminated from most of that region simply by means of unpunished private violence, such as assaults on Egyptian churches where government officials stand by and watch. So much for religious liberty. I now must say a few words about government support of religion, which was universally approved and practiced in the founding. I admit that government support was in some cases controversial. Taxpayer funding of specific ministers or Christian denominations was accepted in most of New England, but rejected elsewhere in America. The crucial point for us is that other forms of government support were not only tolerated, but approved. Take the example of Jefferson. His famous letter to the Danbury Baptists calls for a separation of church and state, meaning there will be no federal funding for specific Christian churches or federal official doctrine of religious orthodoxy. But the same Jefferson famously asked, quote, "Can the liberties of a nation be thought secure when we have removed their only firm basis, a conviction in the minds of the people that these liberties are of the gift of God, that they are not to be violated, but with his wrath?" In other words, Jefferson admits that government has a real interest in promoting sensible religious opinions. Consequently, in his first inaugural, Jefferson praised the prevailing religion in America as supportive of public morals. Here we find a government official in America using the power of the presidential pulpit to support religion. A separation of church and state, clearly required at the federal level by the First Amendment, does not prevent federal officials from giving their blessing to the kinds of religious opinions that are supportive of the laws of nature. Congress got into the act in its 1787 Northwest Ordinance, which spoke of the importance of religion, morality, and knowledge as part of public education in federal territories that have not yet been admitted as states. Does government support of religion violate religious liberty? Today, probably most people, well, I won't say that, many people would say it does violate that principle, but not according to most founders. The logic here is simple. When government supports religion, no one is being punished for their religious opinions. You might not approve of the religious opinions that government promotes, but you also might not approve of the curriculum of Jefferson's University of Virginia. My rights are not being violated by an expenditure of taxpayer money on a cause that elected officials think will promote the security of natural rights. My second theme is property and economics. The natural right to property in the founding is briefly explained by the Virginia Bill of Rights, which says, quote, "All men have certain inherent rights, including the means of acquiring and possessing property," unquote. I repeat, acquiring and possessing. The right to mere possession is not enough. There must also be some means of acquiring more than what one already has. In this way, property rights will benefit the poor as well as the rich. The founders' critics often miss this point. One of them, law professor Kenneth Karst, writes, quote, "The protection of property and economic liberty is something that matters only to people at the top of the heap." Karst would be right if the founders had failed to protect an effective right to acquire property, but they did not fail to do so. In the 2008 presidential campaign, Obama, defending his proposed tax increases, told Joe the plumber, quote, "It is not that I want to punish your success. I just want to make sure that everybody who is behind you, that they've got a chance to succeed too. I think when you spread the wealth around, it's good for everybody," unquote. From the founders' point of view, Obama was getting at an important truth. If everyone has a right to acquire and to possess property, a conflict between the haves and the have-nots will be unavoidable in a condition where the have-nots are unable to acquire what they need. Those who are starving will have no alternative to theft or violence, using force to spread the wealth around. That conflict must be avoided if the property right of owners is to be justly protected. The founders' natural right to possess and to acquire property therefore leads to an urgent practical question. What government properties enable owners to keep their property while enabling the poor to acquire property? The answer requires an understanding of how production works. Economic analysis thus turns out to be an essential part of an account of the founders' theory of natural right. Unfortunately, leading government officials today, and this goes way beyond President Obama and includes many Republicans too, have lost sight of this kind of analysis, or rather they never knew it to start with. I will sketch three main founding era policy principles, and then the policies that follow from those principles, that make possible sufficient production for rich and poor alike of the goods that are needed for life, liberty, and the pursuit of happiness. First principle is privatization. Government must defend and protect private property, including broad freedom to use it as one chooses. Second principle, free markets. With few exceptions, everybody must be allowed to sell anything to anyone at any time or place at any mutually agreeable price. Third, stable money. Government must establish a recognized currency whose value is reasonably constant and hard to change. Madison's little essay on property contains some of the points I am about to mention, but I put together the whole list of the policy consequences of property rights by consulting multiple founding documents that touch on this theme. Let me go into this a little more. First, with the principle of private property. Several policies adopted during the founding era contributed to this end. I will mention 5 of them and then explain. First, government must define clearly what constitutes ownership. Without clear title, there can be no mortgages, no title insurance, no use of property as collateral for loans, and no confidence in the continued right of possession for those who might want to improve their property. That is the situation in most of the world today outside of the Western nations. Ownership is de facto determined by who happens to occupy physically a piece of land or a building, or who happens to be in control of the government. Title is therefore always in doubt. Second principle of private property, there must be few restrictions on use. The owner alone, no one else, and especially not government officials claiming to be experts, is most likely to know the best use of property. So there must be minimal government restraints on free use. Third principle, government must promote widespread ownership. This will enable property to be put to maximum productive use and to hold open to the poor the opportunity to acquire. Thus, the early policy of distributing public lands at relatively cheap prices to as many people as possible. Fourth, government must protect owners against harm to property by fellow citizens or by foreign nations. Without a strong national defense and an effective criminal law to imprison robbers and thieves, none of the 3 policies just mentioned will suffice. Government secures property rights against foreign violence by maintaining strong armed forces. In most of the world today, including some American cities, the laws do not reliably protect businesses and personal property against violence. Fifth, in support of the right to own property, government must protect owners against harm by government itself. Government can deprive someone of property just as effectively as fellow citizens or foreign nations. The founders' remedy was to allow government to take property only by what is called due process of law. This meant only by laws duly enacted and enforced with judicial procedures to protect the innocent, such as the right to a jury trial, the right to hire a lawyer, to examine witnesses, and so on. Today, government is given wide leeway to seize property without having to prove in a court of law that a law has been violated. Drug laws allow officials to seize cars and money without trial. The IRS routinely freezes people's bank accounts and credit for months merely on suspicion of wrongdoing. Most government searches of private property today, regulatory inspection, take place without search warrants, in violation of the original meaning of the Fourth Amendment. I turn now to the second major policy area that government has to be active in order to secure the right to acquire and possess property, and that is free markets. In order for specialists in the various productive skills to get what they need from each other, they must have the opportunity to exchange what they produce for things produced by others. Otherwise, there could be no division of labor, and everyone would have to produce everything for himself. That would guarantee universal poverty and starvation. For the founders, free markets were secured by three main policies. First, in general, everyone must be allowed to sell anything to anyone at any price. Second, contracts must be defined and enforced. And third, there must be equal access to transportation. Let me explain. The first point, freedom to buy, sell, and give. The right to take hold and dispose of property, either real or personal, was one of the privileges of citizenship protected in the U.S. Constitution, according to the predominant interpretation of pre-Civil War federal courts. This right was in conflict with the colonial practice of primogeniture, keeping property intact and giving it all to the eldest son, for example. The founders also opposed monopolies, a second limitation on the right to buy and sell. The right to go into business in any state on the same terms as others was originally a privilege of citizenship protected in the Constitution. Not today. Today, a monopoly is often defined as a private company that dominates a particular market, such as Microsoft. In the founding, however, a monopoly is a government grant of exclusive advantage of commerce to particular persons or entities. Today, it is customary for government to establish quasi-monopolies through licensing requirements, which limit market entry in a variety of areas, from air conditioning repair to public transportation to cosmetology to public utility. Licensing has the effect and often the intention of making it difficult for new or small businesses to compete. A second policy that guarantees free markets is the freedom of contract and adequate judicial enforcement. There has to be clear legal definitions of what is a contract. And there cannot be government interference with contracts once formed. That even made its way into the federal Constitution as a provision: no state shall pass any law impairing the obligation of contracts. In the founding, a contract between two individuals or associations was understood as a sign of equality between the two. Each agrees to give up something of his own property in exchange for property that he values more than his present possession. In an employer-employee relation, the owner has money he wants to exchange for labor, while the workers have, as Madison describes it, free use of their faculties and free choice of their occupations, which constitutes their property in the general sense of the word. Before the Civil War, abolitionists talked about freedom of the northern worker in terms of self-ownership and the right to contract, in contrast with being a slave, which meant that one was not free to sell one's own labor on the market. Freedom of contract today is viewed in a very different light. most nations, America included, now impose extensive limits on freedom of contract. For example, by minimum wage laws, by laws allowing unions to coerce employers into bargaining, and by laws denying employers the right to hire and fire as they choose. I'm thinking of affirmative action laws, disability laws. Finally, for market freedom to exist, government needs to guarantee equal access to transportation on the same terms for all. This, too, is one of the privileges of citizenship protected in the Constitution and by the state governments, which included the right to travel and to have access to common carriers, such as coaches, ships, and later railroads. This brings me to my third big policy area in regard to how government secures the right to acquire and possess property, and that's stable money. And I'll just say a quick word about it. The idea is that after the disastrous experiments in the 1770s and 80s with paper money, the founders finally came to agree that government should mandate a gold and silver standard. This part of the Constitution is, of course, universally ignored by all politicians, including those who claim to be constitutional conservatives. Now, with regard to regulation of commerce, someone might raise the following objection. Not only did all the states engage in regulation of commerce, but Congress, too, was given the power to regulate commerce among the several states. Does this not demonstrate, one might ask, that the founders were not as devoted to free markets as I have just suggested? The answer depends on what sort of regulation we are talking about. Some regulations are market-friendly because they benefit property owners generally. This would include regulations such as prohibitions of excessively loud or dangerous use of property in crowded neighborhoods. Or another example would be an early federal law requiring steamboats on the Mississippi to carry lanterns visible to other vessels. These kinds of regulations are meant to enable every owner to enjoy the use of his own property as much as possible, consistent with other owners' enjoyment of their property. Negligent use of property, such as reckless driving, can lead to fatal accidents. And here, too, regulation was thought to be appropriate. These are so-called police powers regulations that protect the public health, safety, and morals. They do not conflict with the founders' natural law theory. In fact, they are required by it. Government also approves of intrusions on private property in taxation. I mentioned in my earlier lecture that the inalienable right to liberty and property has to be conditionally alienated to government in order for the rest of one's rights to be better secured. Government thereby acts as trustee to protect all of one's rights as much as is possible, humanly speaking. In taxation, we alienate part of our property to government to enable us to have greater protection of the rest of our property from government. As I've indicated here, laws needed to secure property rights are numerous and complex. Who even understands all of this today? I hear a lot of talk about the importance of property rights, but not much about the three areas of government policy that have to be implemented for those rights to be protected, as I've just sketched. We today have mostly forgotten why all these things are needed. When the United States sent Harvard economic experts to Russia in the 1990s to advise them on how to set up a free market economy, most of them forgot to mention the importance of property titles, enforcement of contracts, equal freedom and access to transportation, to say nothing of the dangers of paper money, which it is considered heresy today to criticize. The third policy area of this lecture is one that we today have lost touch with even more than the area of property rights. It seems strange to us that a political society whose purpose is to secure life, liberty, and property should concern itself with citizen character. Harvey Mansfield formulates the paradox nicely. Quote, "Liberty and virtue are not a likely pair. At first sight, they seem to be contraries. For liberty appears to mean living as you please, and virtue appears to mean living not as you please, but as you ought." Unquote. But morality is not something that government can choose either to concern itself with or to ignore. The moral law, in the founders' view, is not in tension with or supplemental to the natural law theory. It is its foundation. The founders tended to equate the moral law with the law of nature. In an official paper written in 1793, Jefferson, then Secretary of State, asks what standard a nation should follow in the conduct of its foreign policy. And his answer is, besides international agreements and customs, quote, the moral law of our nature, unquote. He explains, that is the moral law to which man has been subjected by his Creator. The moral duties which exist between individual and individual in a state of nature accompany them into a state of society. Questions of natural right, Jefferson continues, are triable by their conformity with the moral sense and reason of man, unquote. In a private letter written much later, Jefferson repeats this view. Quote, the people in mass are inherently independent of all but moral law, unquote. So, the moral law, the requirement that we respect each other's life, liberty, and property, must be enforced. The only question is how. Washington's remarks on religion and morality in his farewell address are based on the idea that the threat of legal punishment, while necessary, is not sufficient to create a body of citizens who will be habitually inclined to obey the laws. Washington writes, quote, of all the dispositions and habits which lead to political prosperity, religion and morality are indispensable supports. They are the great pillars of human happiness, these firmest props of the duties of man and citizen. The mere politician, equally with the pious man, ought to respect and cherish them, unquote. Washington says the mere politician, by which he means even non-believers, if they are thinking clearly, cannot help but approve of government support of a religion, whether true or false, whose commandments on property rights and keeping one's oath makes all men's rights more secure to the extent to which they are obeyed. Washington has in mind at least these two of the Ten Commandments, thou shalt not steal, and thou shalt not bear false witness. For Washington, natural rights guide government policy towards support of religion for the reason that religion supports the moral disposition needed to sustain a free society that secures our natural rights. This approach to religion is part of the answer to those who argue that the founding was some sort of amalgam of multiple and perhaps conflicting traditions, as I often hear among scholars. For Washington, together with the other founders, government's main guide comes from only one tradition, the laws of nature and of nature's God, and the unalienable rights of mankind. But, the founders thought, it is only prudent to make use of the support of other traditions, if they are available. In America, that meant Protestantism, English customs, the common law, and so on. In this way, government's policy to secure our rights leads logically and directly to the need for government to promote good character in its citizens. The founders did not underrate the force of law itself to make men moral, although they knew that threats of punishment alone are never sufficient. I will conclude by talking a little bit about the founders' policies to promote and sustain the family. The connection between laws on sex and marriage and government's duty to secure the natural rights of all is today probably less well understood than almost anything else in the founding. These laws all had one main object: to encourage people to get married and stay married. The integrity of the family was believed to be necessary to the protection as well as the happiness of human beings, men, women, and children alike. The love of married parents for their biological offspring was judged the most reliable motivation for the sometimes unpleasant duties of providing suitable care for children. Although it was written some years after the founding, an 1836 essay by Joseph Story, who was appointed to the Supreme Court by President Madison, sums up the founders' view very nicely. Quote, "Marriage is an institution which may properly be deemed to arise from the law of nature. It promotes the private comfort of both parties. It tends to the procreation of the greatest number of healthy citizens and to their proper maintenance and education. It promotes the cause of sound morals by cultivating domestic affections and virtues," unquote. This older, child-centered view of marriage has been replaced in our time with a sentimental romantic love view. The idea of same-sex marriage makes perfect sense in a world where marriage has effectively been redefined as a partnership of people who love each other and who feel justified in splitting up if love happens to fade. As marriage collapses throughout the Western world, children's support comes increasingly from more productive men coerced by the state into transferring money, either by court-ordered child support or by taxation that funds welfare and other benefits, to less productive mothers who choose to live apart from their children's fathers. Criminal law in the founding concerned itself with the family in various ways, all of which were meant to discourage giving birth to children outside of marriage. And I'll give just one example here. Bastardy and adultery, which were crimes in the founding and were prosecuted even after 1790, especially and primarily because these crimes threaten to impose on the community children who will not be provided for by two parents. A child born outside of marriage will not likely be raised by a married mother and father, and adultery often leads to the abandonment or divorce of a spouse. Probably also for the same reason, paternity lawsuits succeeded regularly after 1790. These lawsuits penalized the father of an illegitimate child by making him pay damages to the mother. In this way, the law focused on actual harm to the community from non-marital sex as opposed to the sexual activity itself. Scholars estimate that from 1761 to 1800, 33% of all first births to married women occurred before the 9th month of marriage. And yet, the proportion of out-of-wedlock births in that period was very low. About 5 to 6% in Philadelphia, probably lower elsewhere. What this means is that although many women had become pregnant before marriage, they almost always got married in time to avoid giving birth to an illegitimate child. And this was in accordance with the founders' general approach to this question. If you do something wrong, try to get it taken care of before its consequences become public and possibly injurious to the society and to yourself. Legal historian Lawrence Freedman explains the earlier American view well. The laws regulating sex, he said, were strict, but they were not anywhere near as often enforced as we might expect, unless the misbehavior became open and notorious. The contrast with colonial law, he writes, is extremely sharp. The colonials make no distinction between just plain sin and open and notorious sin. If anything, colonial Americans hated concealed sin more. After the founding, the real crime was to act in such a way as to offend public morality. Hence, vice won a certain grudging degree of toleration or even acceptance, as long as it remained in the shadows. The point, writes Freedman, was to build structures of justice and social order that encouraged self-control, enthroned models of right behavior, and punished extreme deviance. This would drive vice into dark corners and back alleys, which was where it belonged. Not extinct by any means, but in a cage with specific parameters, unquote. Americans of the founding generation and throughout American history up to the 1960s were firm in their public opposition to adultery and other kinds of sex outside marriage. But in practice, in spite of the harshness of some of these laws, earlier Americans discouraged such behavior mainly by means of shame and dishonor, not by judicial punishments. Misbehavior of this sort was tolerated if discreet. For the most part, the de facto policy on sexual misconduct from the founding to the progressive era, and it was in the progressive era that government became much more intrusive in the enforcement of sexual morality. But the earlier policy was, in effect, don't ask, don't tell. Above all, keep it away from public notice. I've talked today about 3 policy areas: religious liberty, including government support of religion, property rights and economic policy, and morality and family law. We today think of these as discrete areas that we all hold distinct views on. Libertarians like the founders' view of property, but abhor their approach to morality and the family. Social conservatives like the founders' family policies, but don't care much about their ideas about economic liberty. Liberals like the founders on religious liberty, but not much else that I have described today. My point is to show how the founders thought of policy as a unified thing, all parts supporting government's main task, to secure these rights on the basis of consent of the governed. Thank you for listening.